Whenever you're ready, counsel, you can begin.
Good morning. I'm Mike Giletti. I'm here for the appellant Ryan Doyen. And briefly, this is the case where he was the victim of a robbery, chased the robber, ended up shooting him, killing him, and he was convicted of a lesser included offense of manslaughter.
Manslaughter.
Yeah. The problems we have are, you know, I've been doing this a long time, but they're remarkable in this case. It's the defendant had an earlier trial. He had a stand your ground motion, and everyone over the course of probably years knew that the defense was that he was a victim of this robbery, that the so-called victim or the deceased, Pike, was in the course of the robbery, and that under the very unusual circumstances of this case, he was able to prove the whole entire circle of that defense. However,
let me interrupt you there,
please.
Because to me that I want to cut to the chase here, because and I understand what you are referencing in terms of the record in this case and some of the things that transpire. However, the assumption that underlies all of your arguments is that this man actually had a defense based on the set of facts that he wasn't able to fully develop. The way I have read your arguments and this record is, even if he'd been able to fully and fairly develop all of these facts that were not allowed in to the second trial, he still had no defense, because under the stand your ground statute and our law of self-defense in Florida, you cannot chase the robber down the street and gun him down and kill him.
Well, and Judge, I appreciate you cutting to the point. Well, the jury found that he couldn't, to the extent that it was a manslaughter. However, we can't assume that there was no defense. We can't assume that he got a fair trial because there was a lesser included offense. Not at all. Not at all. He did have.
No, I'm not assuming that, but the heart of my question is, from my perspective, and based on what I've read in the briefs, you haven't cited any law that would convince me that under the law in Florida, that what this gentleman did constitutes justifiable use of deadly force, which was what you wanted his defense to be. But you haven't shown me anything that would convince me that you're correct about that. And as I understand the argument in the trial court, the way that trial counsel tried to make that defense work is by expanding the robbery to include the time that the quote victim was fleeing.
Judge, well, at the first trial, and the reason I bring that up is because it was a sudden switch. At the first trial, the jury was properly instructed as to the law in the state of Florida that if it's a continuing occurrence, if it's a flight after or after an attempt, then that is something that they can continue as a continuing offense. They can consider that. Now, that was changed suddenly. Whether or not that would be a effective defense, it certainly is the law in the state. You can't change it right before the closing argument.
That's where I'm missing your argument, because I didn't see anything that established that that is part of the law of self-defense, of justifiable use of force. It is if you're looking for enhancements or if you're trying to determine whether somebody's guilty of robbery or not. But it appears, and I think the trial court concluded that your argument is conflating the two. So can you point me to the case law that says, for the purposes of justifiable use of deadly force, the robbery encompasses the time that you're fleeing?
Judge, all I can point to you is the standard jury instruction that says exactly that. And you see in point 3 of our argument that, I could find it here for you, I'm sure, given a second.
Well, I've read the jury, I've read the record, and I've read the jury instructions and the proposed jury instructions. So I'm familiar with it.
All right. So whether or not it was going to be considered at that point by the jury, whether or not they would say that that was part of that. Now, don't forget, as this fellow was leaving, as he was running away, he still had his pistol in his hand. And he told the defendant, "Don't follow me or I'm going to effing shoot you." So that was a continuing situation. Did the jury have the ability to look at this and to do this as a continuing? Certainly, if number one, if they're properly instructed. Number two,
let me interject here,
and I want to stay on point.
Can I interject? Because there was a conflict in fact as to whether the victim still had a gun. So that's a jury question. You got your instruction on robbery. You got this full standard instruction that even included the taking involved subsequent to the taking. You got that instruction. What you asked for was to inform the jury about flight. Well, that's not in the instructions. That would have confused the jury, because you've got to juxtapose subsequent to the taking with the justifiable use of force of your client being in imminent fear of death, when the facts are undisputed that you have a victim running down the street as opposed to running towards your client. And the judge thought that will confuse the jury. And that's an issue of discretion. So tell me how the judge abused their discretion here.
Judge, because of the fact that the undisputed testimony, all right, the undisputed testimony was that that Pike was armed, that he was continuing to point the gun at the defendant as he threatened to shoot him if he was going that way. Also, the undisputed testimony by the defendant was.
Excuse me, let me interrupt you, because I agree with Judge Sleet. I think that was hotly contested, whether or not he was armed.
Sure.
And I understand you think the state just made up the planting of the gun.
Absolutely. It was hotly contested in an improper and prejudicial way. There was nobody to say anything other than the fact that he put the gun against his forehead, that he robbed him, and that when he was found to be lying in the grass, the pistol was still either in or near his hand. There was no testimony that that was under any type of contention. The state, and please remember, because I've never seen anything such as this, the state then raises this issue in the most scurrilous way. Well, if he would have been planting a gun, Miss Witness, would you have seen it? Well, not necessarily. There was no indication that he was planting a gun. The only DNA on that pistol was Pike's DNA, and yeah, it was hotly contested.
And that
through the
into evidence, correct? The DNA that came into
what came into
evidence,
evidence?
The DNA on the gun.
Correct.
That was, the jury heard that. And it seems to me there was,
Through the defense.
This was an interesting record to read, because I think there was conflicting testimony on, was the gun in his left hand, which was under his body, or was it laying by his hip? I saw both. I saw testimony that the gun was clean. There was no blood on it, but there was blood everywhere else. Then I saw testimony that there was blood on the gun. And he was right-handed, but he had a cell phone in his right hand. But there was all this testimony, I guess, from the defendant, and whoever thought they testified that they found him with the gun in his left hand under his body. So, you know, there was a lot of different, there was conflicting testimony on that.
Judge, and I say
Isn't that
this
right?
with all the respect I can muster, there was no testimony that somebody put a gun there. There was no testimony to contradict the fact that Pike
No.
had that gun. And as a matter,
No,
I'm sorry.
no, it was an inference. I think that the state was asking whether it was proper or not. The state was asking the jury to draw an inference. Nobody testified specifically. I saw the defendant's father go and drop the gun next to the victim. No one testified to that. I agree.
And so what you're saying is that the prosecutor was justified and it was a legitimate argument for him to imply to the jury that there is other information that somebody planted the
No.
gun there with
No, I
absolutely
am
no
not,
basis?
I am not, excuse me, I am not saying one way or another what I think about the prosecutor's tactics in this case. I'm not commenting on that. I am just commenting on the fact you said, oh, so there was evidence? No, I didn't say that. What I said is that the state was asking the jury to infer that based on the evidence that was in front of the jury. Whether that was proper or not, I'm not commenting on.
Well, Judge, we need to comment on that because that's a major issue. The misconduct by the prosecutor doing that
Has
as
anyone,
he shifted
has
the
anyone
burden.
complained? Has anyone filed any formal complaint with the state attorney's office or the Florida bar regarding the conduct of the prosecutors in this case? Do you know?
I don't think that they did. Right now, my interest is to get the guy out of jail and get him a fair trial. I'm not interested in attacking the prosecutor anymore. It was raised.
Well, that's part of
We
your
did have
brief is to
the
attack the
transcript of-
prosecution. That's
Sure.
part of your
Because-
argument
not to
on
get
appeal
his
is that the
license
prosecu-
suspended.
Is that the
Go
prosecution,
ahead.
there was so much prosecutorial misconduct that this gentleman did not get a fair trial. And we should reverse his judgment of conviction and remand it for a new trial. Is that not part of what you're arguing?
Sure, and Judge, if you want to add to that in the order reversing for a new trial, if you also, as is often the case, refer this matter to the Florida bar to have that the actions of the prosecutor to be reviewed because it was so blatant, that's fine with me.
Well, no,
But my
that's not,
concern
you know
is-
what? Let me interrupt you, sir. I would think that the people who were involved in this trial are in the best position to decide if that's appropriate, not this court. So I'm going to stop you right there on that. Because all we have is this record and we don't know everything. We just have a record of the trial. Number one.
Correct.
And what you're arguing about the prosecutorial misconduct and this gentleman didn't get a fair trial brings me back to my original question. Let's undo everything that happened. Everything, all your complaints about the prosecution, your complaints about the judge's limitation on what was allowed in evidence. Let's say you were able to fully develop that this guy planned and carried out an armed home invasion.
Okay.
Just exactly as you are suggesting happened. How
Correct.
is there any defense to the robber leaves? He's out the door. Your client grabs his AR, whatever, his semi-automatic rifle, gets up, chases him out the front door and down the street, firing all the way, trying to shoot him down. How is that a legal defense?
Because he is running directly to the home of the defendant's mother and father who live in that corner house right around the corner. He's going in that direction, number one. Number two, he
Well, there
doesn't
were
know
a
if there's any
number
other
of houses on
conspirators
that
there.
street. I mean, there's houses all up and down the street.
Which don't make any difference. You're asking me, is there a legal defense in Florida of the defense of others when there's an armed robbery going on? There sure is.
What was the imminent?
And that's what he testified to.
What was the imminent threat? There has to be an imminent threat. I mean, the only
Correct.
reason that the defendant faced any threat, if you believe his version of the events, is because he put himself in danger by chasing this man who he says was armed and threatening to kill him.
Well, and Judge, isn't that, and I say this with a little bit of a smile, isn't that exactly
Okay.
what the prosecutor improperly argued? If you believe him, then it could be self-defense. But wait a minute, there's no proof of self-defense. You don't. They rely upon you believing him on the self-defense, which is a burden shifting on the absolute issue. You can't do that. And then when you combine that with the fact that, gee, when did you stop beating your wife? Could you have seen him planting a gun? There is no indication. Don't forget, Judge, and I say this again respectfully, I'm just running out, so I'm talking fast. Don't forget also, the prosecutor knew there was a gun. The prosecutor knew that the one fella took it away from him. He knew that he was going to hit a lick, and all that was kept away from the jury.
Sir,
So therefore,
I am
the jury.
sir, let me interrupt you for two reasons. Number one, I am completely aware of that. I have read this record thoroughly. Number two,
Okay.
you're at a point where you have about 4 minutes left for rebuttal if you'd like to reserve some time.
Judge, I always hate to interrupt when we're talking back and forth. So please tell me if you have any more questions. I think that's more important than talking about what the state has to say, which is probably not a whole lot based on what you're saying. But
I'm just one person, and I like to be very upfront with my questions to give you an opportunity to respond. So if you'd like to reserve the rest of your time, then that's fine.
Judge, let me say this, and I'll reserve the whatever 30 seconds I have left, but let me say this. There is a combination of everything that's happening here. The state knew what was going on. The jury didn't. The state implied there was other evidence that the jury didn't know. And that was the case with the gun, with the planning of the gun. But you can't exclude from the jury the motivation and the thought process of the victim. And that's the problem. That's the beginning of it. The state knew about it when the court kept that out improperly, claiming it was hearsay, which it wasn't on any of the several levels I laid out. You can't then come in there and take advantage of the defendant's hands being tied and argue nonsense. The gun was planted. He has the burden of proving the self-defense. Yeah, and I'd say that's not nonsense because that's not the law. The state has to prove it was not self-defense beyond a reasonable doubt, not shift the burden effectively as they did in their argument. And Judge, I'll save the last 40 seconds unless you have some more questions there.
Any questions? Okay, thank you, sir. Thank you.
All right, thanks.
Mr. Campbell, you need to unmute, please. Thank you.
Yes, ma'am. Good morning. David Campbell, representing the state of Florida. I think you
So,
said
Mr.
a lot
Campbell,
of the
I'm going
argument.
to jump in just like I did for your colleague there and ask you, what was the state thinking here in the way that they tried this case?
You know,
It's
I
probably a
really
really
can't.
unfair question.
I didn't really go into a lot of what their mindset was. I was just mainly concentrating on whether or not all the evidence he was talking about was unfairly kept out.
As hard as the state worked to keep the jury from learning that there was evidence that this man had multiple witnesses that could testify that he had planned this robbery, and that there was someone waiting in a getaway car to pick him up, et cetera, all the things that the state worked really hard to keep the jury from knowing. in this, hypothetical planting of the gun that they interjected into the proceedings. I mean, if they, they worked really hard to keep that out to the point that it makes me think, well, maybe that is a defense, or maybe they thought it was a defense, that under all those circumstances, you get to chase the robber down the street and shoot him.
Your Honor, as far as all that evidence goes, they were working hard, but I think they were also at the same time more going by the strict letter of the law and not letting in, hearsay. Granted, the extraction reports and stuff themselves are not hearsay, but the contents contained within them can be hearsay. The main witness, Ms. Palmiero, she actually didn't testify, but we do know from the deposition, and which came out during the hearings, she had denied making all those statements. So she seemed to be the main witness who was there. And the judge said that, she can come in, she can say what she saw, that, she drove him there, that she saw him get shot in front of her, everything she witnessed. However, she didn't come in. And that was, her testimony would have been a lot of what the defense is trying to get in. But I think as the judge wrote when she denied the stand your ground hearing, the defendant actually that was not a defense. And as far as him being concerned about other people, as was even noted, after the victim had been shot and rounded the corner, which would have been heading towards his parents' front door, the defendant stops. He doesn't go around and see, did I kill this guy or not, or is he still a threat? So I think the defendant's own actions right there take away a lot of, whether there's a burglary or not, once the man was out the door and fleeing, which is what the two witnesses said, I think one of them said he was like running for his life. At that point, stand your ground does not let you go shoot somebody in the back. So even though this, in some ways, it might have just been way more confusing to the jury to put in all of this talk about a robbery when the sequence of events we're concerned about actually happened after he fled and got out the door. If the defendant had shot the victim, on his front step or inside his home, we probably wouldn't be here. But in some ways, relevance, in a way it isn't, because what happened when the defendant came out of his house with the gun and was chasing him down and firing after him? I believe he stopped and took aim, I believe 3 times or whatever. There were 3 bursts of fire. So, it was hearsay. Maybe they should have brought Ms. Palmiero in and had her, proffer.
Well, excuse
right
me. I guess anyone was entitled to bring her in. And if she changed her testimony, she could always be impeached with her statement. But, what was really interesting to me is the state didn't even call the lead detective that investigated this. The defense had to call the detective. How often does that happen?
Well, usually, obviously, they normally called in. A lot of times there's more stuff that, needs to be done about the investigation. I do think in this case, though, the state kept it to what they needed to. He chased the guy out of the building and gunned him down. So actually, a lot of this talk about investigation of a burglary really wasn't relevant to the state's case. That all happened beforehand. This is kind of unusual that we have.
No, I believe it was the lead homicide detective was not called by the state. The defense called that detective.
Yes, they did. And I think they were also.
And I think part of the defense was you didn't even investigate the robbery. I mean, they were faulting the police for not investigating the robbery.
Well, yes, they were. But once again, I think the state, that wasn't actually the charge. They were charging the defendant, not the victim who was the robber. They were charging the defendant. His crime was, they were charging him with second-degree murder. So they were, zeroing in on what was important for their case. This, I do agree, was interesting. And it would probably put, whether he was there for a robbery or not, I don't think actually matters in the end. The jury would like to know it. The defense would obviously like to get it out. But was it actually critical for the state? He was there for whatever reason. Assuming he was there for a robbery, you can even, give them that. I mean, that did come out too. We did get Ms. Meyer's testimony that he was there to hit a lick, and the defendant himself said that he was being robbed and the gun was put to his head. So the jury had that. And apparently they believed some of it because they ended up finding him guilty of manslaughter. But really, for the state's charge of murder, it wasn't necessary. In this case, it just wasn't really relevant for that sliver of time that the state was concerned with. So I don't know if it was necessarily something nefarious in this case. Are there any other questions here? I'm trying to think. well, I did mention about it being the contents of all that evidence. There can still be hearsay within it. And trying to think. As far as the other issues, I don't believe that there was anything with the jury selection. I think actually jury selection was doing exactly what it was intended to. And the defense didn't object to the jury. They accepted it. They used a lot of their peremptories, never asked for any others. And so that would be waived. Is there any other particular issue that there's any questions on?
I don't have any questions. Judges? No, I think,
I would just say then that, the period of time necessary for the state was when the witnesses saw the defendant coming out with his rifle, following the guy down and gunning him down. What happened before then actually wasn't really relevant for the state. And with that, we would ask you to affirm.
okay,
Thank you very
thank
much.
you. All right, sir.
Can I
Rebuttal?
make it, can I use a couple of minutes? Yeah.
I'm gonna give you 2 minutes for
There's
rebuttal
so
because
much-
I took a lot of your time talking to you.
No, that's fine. I could use the rest of his time. All right.
No, you
First
can't
of
do
all-
that.
First of all,
I get to give you
Paul
time.
Murray-
You don't get to take time.
I understand. Paul Murray was available. The judge made it clear and chastised Attorney Aiken that she's not coming in. You have to read my order again. I did a sophisticated order. So she was prevented. So don't be misled that, oh, she wasn't going to come in. She wasn't allowed to come in and she wasn't allowed to say anything.
But she
Number
was
two,
allowed to
this guy was
testify,
not
but she
shot.
was allowed to testify as to Pike's statement. That was clear. It's in the record. I read it. She was allowed to testify
Correct,
as
but-
to Pike's statements. So she could have come in and conveyed to the jury, Pike planned and intended to rob your client.
Right. On the other hand, she was prevented from saying that it was all my fault. This was a lick. He needed to come in there because he needed the money and all the other things that were there that he had the gun beforehand. And by the same token, not Megan, I'm sorry. The other girl, Amanda Myers, was not allowed. She came in and she was hamstrung, as was the defense. She was allowed to say only that this was going to happen, not that they had planned it, not that she tried to talk him out of it, not that he had the gun beforehand. All of that came out. It didn't come out. It was kept out. It didn't come out before the jury. The other problem is, as the judge said, they hid the lead detective because she's the one that did all those statements. They didn't bring the lead detective in. We tried to bring it in on the side of the defense to show the jury the whole situation. They hid the tech who found the bags of marijuana that had the blood of the defendant on there. So how in the world they knew that, yet the prosecutor argues there was no robbery? Of course that robbery is critically important. Of course it is, because it's how he responded to that. He was not shot in the back. He was shot under the arm, which was the left arm, as he was pointing the gun back, and they had a big progression about that with the ME. So he wasn't shot in the back. He had the pistol. He was threatening him, and that's where the shot went in, under the left armpit, coming out of the chest, not in the back. And we brought in pictures. The defense brought in pictures.
Ad nauseum.
It's, absolutely, but you have to show what they're trying to show the whole situation. Why was Pike there? Well, he was there, as the evidence all showed, and as the prosecutor knew, because this was set up. They tried to talk him out of the robbery. He had a pistol. One guy took it away from him because he tried to get him to go along with it. All that stayed out in front of the jury. So
Sir, I
was
think-
it a situation where?
Sir,
Yes.
I'm sorry, but you're at the end of your time. And I think we all understand your argument. And thank you both.
Thank you so much, and please take a look at the brief and the other, and then just give me a chance to
You're-
try this case
We
with.
will. We have
information.
and we will.
Thank-
All right, our
Thank you
next
so much.
case this morning is KB Home Fort Myers.